Good day, ladies and gentlemen, and welcome back to another What If video. Today's topic is what if an employee refuses to testify at a hearing or at arbitration. Now, a question often asked is whether an employer can force an employee to testify at a hearing or at arbitration. Many employees and even employers are of the view that employees cannot be forced to testify, but is this indeed the case? In a recent decision of Kafer Energy Projects versus the CCMA and others, the Labour Appeal Court considered whether an employee may be charged with insubordination for refusing to testify against a co-employee on behalf of their employer. Now, the brief facts are that the employee overheard a heated altercation between two employees, Maley and Govender, and rushed to Govender's office to separate the two arguing employees. Disciplinary action was then taken against Maley and he was dismissed. Maley referred the dispute to the CCMA and his dispute was eventually set down for arbitration. The employee in question was then required to testify at the arbitration against Maley. However, for reasons unknown, she refused to do so. Originally, the employee claimed that she had no recollection of the incident and did not want to make a fool of herself by giving evidence. But she later conceded that she had witnessed the incident and agreed to give evidence. However, shortly before the arbitration, the employee sent a message to the employer that she no longer intended to testify. She was then charged for insubordination and was subsequently dismissed based on her or due to her refusal to testify against her co-employee. It must be noted, however, that the employer, after finding out or knowing that she is not going to testify, never issued a subpoena to her. She took her matter or her dismissal to the CCMA, and at the CCMA, the Commissioner found that since there was no evidence led to show that the employee deliberately refused to testify in order to protect Maley or to conceal evidence, the employee had not committed any misconduct. The Commissioner ruled that if the employee was an important witness, the employer should have subpoenaed her. Ultimately, the CCMA Commissioner found the employee's dismissal unfair. Now, the employer was not happy with this decision and took the matter on review to the Labour Court. Upholding the CCMA's finding, albeit on a different basis, the Labour Court held that the employer could not dismiss the employee for refusing to testify. The Labour Court found that an employer's contractual powers do not extend to instructing an employee to testify against her will, and that the only way to compel an employee to testify is to cause a subpoena to be issued against the employee. The Labour Court subsequently found that the dismissal was unfair. Again, the employer was not happy with this outcome and therefore took the matter on appeal. On appeal, the employer argued that the employee owed a duty of good faith towards the company and that her refusal to testify on behalf of the employer amounted to insubordination. The employer was given a clear instruction which was neither unreasonable nor unfair. Now, the court pointed the following out. In determining whether the employee was guilty, the arbitrator was required to consider the following. Number one, consider the misconduct that the employee was said to have committed, in this case being her refusal to carry out an instruction given to her. Number two, whether the instruction was lawful, reasonable, or fair. Number three, whether the employee was in a position to carry out the instruction. And number four, whether there was a lawful or reasonable excuse for her to refuse to carry out the instruction. The Labour Appeal Court noted that the employee was given a clear instruction which was neither unreasonable nor unfair. She had been instructed to testify and had a duty to comply with that instruction unless she provided a valid and acceptable excuse for non-compliance. The court did point out that while employees are at times threatened or face other pressures from co-employees or their community to stop them from testifying, such concerns would need to be brought to the employer's attention and dealt with accordingly. The court concluded on the facts that there was simply no evidence whatsoever to indicate or from which to properly draw any kind of inference that she may have been threatened or that she feared reprisals from fellow workers if she testified. And thus, no valid and reasonable excuse justified the employee's refusal to testify against her co-employees. The Labour Appeal Court then found that the issue of the subpoena was a red herring. Any litigant has that as a tool to compel a witness to testify. The fact that that tool is available does not mean that because it's not used, an employee witness can simply refuse an employer's instruction that he or she testifies at a hearing, or that that refusal by the employee to carry out the employer's instruction to testify, where the demand is not unreasonable, cannot lead to disciplinary action being taken against the employee. The Labour Appeal Court found that the employee was guilty of insubordination and that this had to be seen in a serious light as the employee had challenged the authority of her employer. The employer had not provided an acceptable and valid reason for not complying with the instruction, and the Labour Appeal Court held that dismissal was an appropriate sanction in the circumstances. So in conclusion, ladies and gentlemen, it is an implied duty that employees must always act in the best interest of the employer. However, it must be noted that this duty is reciprocal. It's a two-way street. In other words, an employer also has a duty to act in the best interest of the employee. If the employee is refusing to testify because they have been intimidated or are threatened, an employer would not be acting in the best interest of that employee when forcing him or her or them to testify. Therefore, going forward, when you require an employee to testify and you realize that the employee is not willing, it's best to establish what the reasons are why the employee is refusing. If the reason, for example, relates to genuine threats being made, an employer cannot force the employee to testify. Obviously, one can be creative and perhaps deal with that witness testimony or evidence in camera. However, if the employee has no valid reason why he or she does not want to testify, typically what we have found is, the employee says, I don't want to get involved, then the employer may take disciplinary action against the employee for such refusal. Ladies and gentlemen, that then brings us to the end of this video. As always, thank you for watching, and I will see you next time. Bye-bye.